Good evening, everyone. My name is Michael Hussey, and this is my Module 12 Tort Liability PowerPoint / Screencast-O-Matic project. So let's start off with what is tort law? Well, tort law is based on the legal premise that individuals are liable for the consequences of their own conduct or lack of conduct when such actions result in injury to others. Pretty self-explanatory. If you're responsible, if you're the person in charge, and your lack of um, doing something causes injury or harm to somebody else, then you are liable. So case number one, negligence. I'm not going to try to pronounce that last name, but it's Donna Andriazzi, the parent of Nicholas Andriazzi versus the town of East Haven in Connecticut. So the case is student was jogging around a track at a middle school, and he ran to a bench which was in one of the lanes. When he fell, he hurt himself. He had displaced fracture of the radius of the left wrist. The mother went and filed a negligence claim against the school, and the court ruled in favor of the school, claiming that the coach had governmental immunity in this situation. Basically, they said the event was voluntary and it occurred after school and off of school grounds. So none of the exceptions to not claim governmental immunity were met, and the coach and the school was let off. If that were my school, some of the reactive measures that we would take right away, and myself too as a building leader and former coach of many different sports, you have to make sure that the safe practice conditions in all athletic arenas and facilities are there at all time. It's about the kids. You got to keep the kids safe. When you're the adult, when you're the professional, the coach, you have to make sure the right equipment is in place, and if something doesn't belong, whether it's on a track, on a field, or in a wrestling room or basketball court, you get rid of it so kids can't get hurt. Kids aren't always going to do the right things no matter what you think. So you got to play it safe. Preventions I would put in place, naturally, coach's job, assistant coaches, whoever, check the facilities, check the fields, make sure everything's good. Same thing can happen with the heat injury. You have to make sure all the preventive measures are in place. Professional ethics, commitment to the athlete's safety at all times. As a coach, it is your job to make sure that your athletes are safe. Plain and simple. Yes, you want them to win, but you can't win without a team. You got to keep them safe. Case number two is negligence again. Rios versus Grossmont Union High School District. So a JV player at the high school, California, 2008, fell and felt his ankle pop when he got tackled. So he left the game and told the coach what had happened. After a couple plays, he was sent back. He was sent in to see the trainer and get his ankle taped. After they examined him, he was cleared to return to play. And after returning to play, he fractured 2 vertebrae. The mother filed a lawsuit stating that the athletic department was negligent in allowing her son to return back to the game so soon. The court found that the district was not negligent in the situation. So the athletic trainer was not on hand at the time. And he saw basically a trainer assistant. California does not require a certified athletic trainer to be on hand at all times. So that's what got the school and coach basically cleared of all charges. Me myself, reactive measures, and like I said, I coached for a long time. I coached football for a very long time. I always made sure I had an athletic trainer on hand at all times, a certified one. The athletic trainer for the school was at all the games. Home games. Now, away games, the other school provided it. But at my home games, I always had a certified athletic trainer at all times. Prevention, try and get the assistants better trained. If you don't have the appropriate trainer on hand all the time at school because conflicts, um, not a full-time gig. I don't know. Make sure your assistants try and give them better training if you can. And you have to have a policy for certain injuries. If they feel a pop, maybe you as a coach say, okay, you're done for the day. But you got to figure something out. You got to put a policy in place that if you don't have a certified athletic trainer on hand all the time, then you as a coach are responsible. So as a building leader, I'd make sure that was addressed. Again, a commitment to the players. You got to keep them safe. You got to worry about them. They're kids. They bounce back quick when they get hurt, but those injuries add up, and the long-term effects of them getting hurt at such a young age, especially with football, you got to be careful. Case number 3, assault. Boone versus Wayne Reese, 2004. His mother filed a suit on behalf of the child alleging assault and battery when a teacher pushed her son into the wall. The courts decided the teacher did not act with malice and the teacher's physical contact was needed to maintain order in the classroom. Appellate court affirmed on the basis that the contact of the student did not meet the definition of battery. So there was a disruption in the class. Teacher pushed the young man to the side, and I guess went home, told his mom, and she tried to press charges. As a building leader, of course, I would naturally do an investigation of the situation. Prevention, train the teachers. You got to let them know. If you're going to put your hands on kids, it's got to be for a very good reason, and it's got to be clear and concise, and there can't be any doubt in your mind that you're doing the right thing for all the kids or that student that you're moving at that time. If it's for the kid's safety, absolutely you do it. But you have to know that's what it's for. So you definitely got to do that. And professional ethics, you got to provide a safe learning environment for your students at all times. Case number 4 was a sexual assault. Ross Feller Casey versus East Town School District in 2017. This one was a very disturbing one that I read. Administrators and teachers at the high school, they created an environment that was okay for this man to do this. Arthur Phelps, a 67-year-old man, instructional aide. He wasn't even the teacher. He was an aide. Repeatedly sexually abused a female student. It started at the age of 15 until 16. He was found guilty and sentenced to 10-20 years. So reading about this case, it was clear that other teachers knew what was going on. And in fact, at one time, he even double dated with another teacher and his wife. Seen multiple times with her out off campus. He wrote 20 passes for her being late to class. She actually missed 20 English classes in 3 months. And nobody questioned it. Not even the English teacher. So this case was pretty disturbing, and a lot needs to go into this one as far as that school. As a building leader, I would be very disturbed if this happened in my school. It would be an investigation, not only him, but other teachers that might have been seen with him to figure out what's going on and what were they thinking and why didn't someone get involved to protect this child. You got to put in place a requirement for teachers and administrators in this case to get mandatory annually ethics training. I had to sit through, I had to take a class called The Good Teacher. It's an ethics course for educators, specifically because of misconduct with teachers and students. When you do the research, it happens a lot, and a lot more than you want to think it does. Professional ethics, again, you got to provide a safe learning environment for your students. If you know or think you know something like this is going on, you got to say something to somebody. You got to speak up. Bystander intervention. It's important. Last case, false imprisonment. School Board of Miami-Dade County versus Trujillo, 2005. This at first was a judge had seen it in the plaintiff's favor, Trujillo's favor. An appellate court actually turned it over in the school board's favor because the student was picked up at the house. A special needs student was picked up at home about an hour late because the bus was running behind. The student ended up getting to school almost 4 hours late. And And so the parents filed a false imprisonment charge against the school. And like I said, at first it was pushed through by the judge, and then the appellate court saw it in the school board's favor because there was no evidence that the bus driver held this child against their will. He got lost. Picking up other students, he got lost. And he didn't do a good job, but he didn't do it to purposely harm the child. So again, I would, investigate the situation, figure out what was going on. But this is something at the school district's level, because when you talk about transportation, the school districts, this is in their area of responsibility. So they need to ensure their all bus drivers know their routes. If they're getting new buses or new routes, then they got to know that where they're going, especially when you're dealing with special needs children. This child, I'm sure, got really scared, didn't know what was going on, is on the bus for almost 4 or 5 hours. It could be super frightening, even for a child that doesn't have any special needs. So you have to make sure they know what they're doing. When you're dealing with special needs, maybe you put a second person on that bus. One, to assist with the children if needed. Two, maybe they would have known that the bus driver was going the wrong way. Maybe they knew he was getting lost. Like, hey, what's going on? Where are we at? Make a phone. They could have made a phone call for him. So you got to make sure that you're covering all your bases with that. And again, as always, you got to keep the kids safe. These are my references for this presentation. And that's it. Hope you enjoyed it. Look forward to seeing all y'all. Have a good day.